Well, I am excited to share the stage today with the real brains behind our operation on the enrollment side, Ms. Teresa
I wouldn't say that.
She is the wealth of knowledge that we utilize every day if we have questions. We go to Ms. Scroggins because she has all of the answers. She can tell you what happened 20 years ago, just like that, and it's truly amazing. We do not have a game show theme today, but we do have questions that we're going to ask throughout our presentation, and we're going to be assisted by some of our enrollments department, Monica Owen, and we've got Beth Montgomery and Latana Worthy. They're two of our newer employees, and they're going to help us out through this presentation. We're going to have a conversation today about our enrollment and eligibility rules and the process of the enrollment process. So we're going to start at the very beginning and talk about, under the local government rules, how do we define a full-time employee?
A full-time employee is an employee who receives a W-2, is in an employer-employee relationship, and they regularly work 30 hours per week or more.
And one thing to point out is this is our rule, right? You guys may have a different definition of full-time for your retiree benefits or something else, and that's fine, but just remember, for insurance purposes, ours is 30 hours. And one thing to point out, how many of you guys have 50 or more employees? Okay, remember, you're also subject to the ACA employer shared responsibility requirements, and so there may be some people who are deemed temporary or seasonal or emergency employees. It's very important that you're tracking their hours according to the ACA rules, because if they're working 30 or more hours or 130 hours per month, they would be eligible. So there's a lot of information on that in our administrative guide, but keep that in mind. All right, we have our first question. It is a true-false question. John Smith is a lawyer at Smith & Associates on Main Street. Mr. Smith has a contract to be the city attorney for the local town. Mr. Smith is eligible for coverage due to his position as a city attorney. If you know the answer, please stand up. The first person stand up. Okay, on the front row.
False.
False. That is correct. Why is it false, Dina?
He's not a W-2, he's a contract employee.
That is correct. So Mr. Smith is not eligible because he is not a W-2 employee. He's a 1099 contract employee, and he would not be in an employer-employee relationship. So he would not be eligible for coverage under our plan. And that is one that we see quite often. We also see city judges come up from time to time because they're contract employees also. All right, some of you guys cover elected officials. Raise your hand if you cover elected officials. All right, Teresa, how do we define elected officials?
An elected official is an individual elected to public office by the vote of the people at the state, county, or municipal level of government. This applies to cities, towns, and counties.
All right, we have our next question. Which of the following is not eligible as an elected official? A, county commissioner, B, city councilman, C, sheriff, or D, water board member? Oh, wait. Who? Here? Okay. Over here. Ma'am? D. You say D, water board member? That is correct. The water board member is not eligible because he or she was not elected by a vote of the people at the city, county, or municipal level. Okay, so we know who the categories are. Let's talk about the enrollment process. When a unit gets a new employee, what's the first thing they need to do?
If the employee is working 30 hours or more per week, then they need to enroll or do a declination and provide proof.
And do we have forms for each of those options?
Yes, we have an enrollment form and a declination form, and then the acceptable proof. The acceptable proof is proof of coverage letter. It could be a certificate of coverage. It could be a letter on letterhead, Medicare card, military ID. But if it's a military ID, we need the front and the back.
What is not acceptable?
Not acceptable would be an insurance card. It could be an explanation of benefits, pay stub. Those are not acceptable.
And really what we're looking for is something with a current date that shows the coverage is still effective. Unfortunately, the insurance card is just a date and time, and it doesn't really prove that coverage is still effective. All right, what are the options for employees when their effective date of coverage?
Date of hire or first day of second month. For an example, if they're hired in October, the effective date would be December 1st.
What about probationary periods?
Probationary period, if your unit has a probationary period, it must be approved by the local government board, and we are no longer offering that option for new units. But if you're currently with a probationary period, you're grandfathered in.
And so we know how our employees enroll or decline. What about our eligible dependents?
Eligible dependent is going to be a spouse, excludes divorce. It could be a child under age 26. If it's your son, daughter, a child legally adopted by you or your spouse, a stepchild, and also this is a change, a dependent under age 19 for whom the participant or their spouse has legal and physical custody granted by the court of a competent jurisdiction. An incapacitated child over age 25 if they meet certain criteria.
And the dependent child is a change from last year. If you'll remember, last year it had to be a grandchild, niece, or nephew. We heard you on that. We took an issue to the board, and the board approved changing this policy to broaden it out. One thing we are going to monitor, though, is to make sure that the people still have active custody. And so every couple of years, our auditing department is going to send out letters to the members just to verify that they still have custody of these individuals. All right, so next question time. Which of the following is not an eligible dependent? 25-year-old son. B, a 17-year-old cousin in which the member has legal and physical custody. C, 15-year-old ex-stepson or 23-year-old adopted daughter. I think it was this one right here.
15-year-old ex-stepson.
That is correct. So ex-stepchildren along with ex-spouses are not eligible regardless of what the divorce decree may state. Sometimes the judge will put that in the order. It doesn't matter for our rules. The ex-spouses and ex-stepchildren are not eligible.
Well, we've talked about who is eligible. So who is an ineligible dependent?
So the obvious answer to that is anyone who doesn't meet the definition of an eligible dependent. I would say that's your starting point, right? I mean, that's step one. But the ones that we see most often are the ex-stepchildren, the ex-spouses, and also employees or spouses or dependents if they're independently eligible for coverage as a employee of another unit. They would
Or it could be the same unit.
Or the same unit, that's correct. You know, we also see grandparents, parents, live-in boyfriends, those type issues. None of those are eligible. And we've got this list in our administrative guide. There's a much longer list in our administrative guide.
Why can't spouses that work for two different places that have local government be on the same policy?
Very good question. That has been the board policy from day one, and it is one. It's a financial issue, quite honestly. It involves just making sure that everybody's paying their fair share, and it's one that we've heard and one that we've talked about taking before the board at some point, but we just haven't gotten to that point yet. All right, so we know who our people are. We know the categories. We know the eligible dependents, who's ineligible. When an employee is first hired, obviously, they can add their dependents at that time. What about throughout the plan year? When can they add dependents?
There's two scenarios. First, loss of other coverage. We would need to be notified within 60 days of the qualifying event. Loss of coverage could be the COBRA coverage exhausted. It could be loss of eligibility due to termination. It could be divorce, death, reduction in hours, substantial change in benefits, premiums. The employer stopped contributing. That's the first scenario. The second one would be a new dependent through marriage, birth, adoption, custody. Those would be qualifying events. The main thing is to be notified within 60 days.
I can't reemphasize that enough. Please notify us within 60 days of these changes. We also have what's called the tag-along rule. Can you explain that?
The tag-along rule is when a dependent becomes eligible due to special open enrollment, then any and all other dependents can be added for that qualifying event.
During the enrollment process, one thing that comes up from time to time are national medical support notices. I don't know if you guys are familiar with these or not, but these are not court orders. These are orders from typically DHR. They're from a child support agency, and they're ordering coverage for a child. And when we receive those, we have to add the child to coverage, and the coverage has to remain in place throughout the duration of the order. And one thing that we see from time to time is you may have an employee who declined coverage because they had other coverage. If we receive a National Medical Support Notice, that employee has to enroll in coverage and elect family coverage to cover that child. All right, now let's talk about canceling
Now
coverage.
let's talk about canceling, because when you think of divorce, you think of dependents coming off. There's two situations for canceling coverage. First is for an employee. It would be death, termination, leave without pay, retirement. But on a dependent, a reason for a qualifying event would be divorce, dependent got a job, open enrollment, loss of custody, Medicare, Medicaid, the dependent aged off. For the qualifying events, we must be notified within 60 days of the qualifying event.
And all of these that we're talking about are things that occur outside of open enrollment. Obviously, they can do these during open enrollment also, but outside of open enrollment, these are the type events that would trigger being able to cancel coverage. One thing to point out on the divorces, it is very important that we're notified as soon as the court order is finalized, because ex-spouses are not eligible for coverage under our plan, right? And so if it goes beyond the end of the month in which the employee or the spouse should have been canceled, there are going to be some claims that should not have been paid. We are going to try to recall those claims, but there are certain claims that cannot be recalled. And at the end of the day, the member is going to be responsible for those claims. And so I cannot stress enough how important it is to tell your people to tell us as soon as you have a court order that's finalized. One thing that we do, we get a report every month from the Department of Public Health with divorces. It's strange that it comes from the Department of Public Health, but it does. It's a report of divorces. And so what I do is I take that report and I log into the court system just to verify the divorce, because every once in a while you will get a false positive. But it's strange, but you will get a name on that report, and then I will log into the court system, and sure enough, there was a final order, but sometime after the final order, apparently they reconciled and they overturned the final order. So there's a couple actually that show up every month. But
Or they could have remarried.
Or they could have remarried. And so we try to catch those, but still that report is lagged too. And so it's not coming in until the following month. So we're catching it on the back end, but we're still trying to prevent it from going too far. All right, so when we cancel coverage, obviously most people are eligible for COBRA. Talk about that process.
Once we receive the cancellation, the first thing we do is cancel the contract or cancel the dependent. And then we send COBRA if it's a qualifying event for COBRA. And then the next thing is going to be, if it's a retro cancel, then we check claims. And that will be when you either get a credit back or you may not get a credit if there's claims involved.
And you send the COBRA notice to the individual and to the member? I'm sorry, to the unit?
We send the COBRA notice to the employee or the dependent. If it's termination, 18 months of COBRA. If it's death, divorce, those are 36-month qualifying events. We send the original to the employee, and then you should receive an email with a copy of the COBRA notice to let you know we did comply with COBRA.
One thing I would point out here is on our cancellation form, last year we added a box for gross misconduct. Under the COBRA rules, if it's just a voluntary termination or involuntary termination, they're eligible for COBRA unless it was due to gross misconduct. And so we added that to our form last year. If that is the case, it's very important that you check that box. Otherwise, we're not going to know any different, and we're going to send out the COBRA notice as we normally would. Sure.
Can you give some examples of gross misconduct, or is there something we can go to?
You know, it's funny you ask that. There's really not a good definition if you look out there. I would just say you know it when you see it, right? It's generally something that involves sort of a felony, something that rises to that level, right? I mean, you know, but it's a higher standard than typical insubordination, I would say. All right, so all of the things that we've talked about, those occur during the year. What about open enrollment?
Open enrollment is the month of November. It's November 1st through November 30th, not December 1st. It's the month of November only.
And what kind of changes can an employee make during open enrollment?
If an employee declined coverage, they can enroll without a qualifying event. They can add dependents, drop dependents without a qualifying event.
And the unit can also make changes during the month of November?
Yes, the unit can. They can add or drop dental under the Blue Cross. They can also add or drop elected official coverage, retiree coverage, and on retirees, whether it's Medicare, not Medicare, if you want to drop that selection, then you can do that during open enrollment also. You can also change the hire date from date of hire to first day of second month, or vice versa.
Right, and one thing to point out there is, remember earlier we talked about our probationary policy change? This is important. If you make a change to your probationary policy, that grandfathering that we did is going to go away. So you're grandfathered now, but if you make a change in the future, then you would not be allowed a probationary period. All right, so all of these things apply to our Blue Cross plan and our Optum plan, our traditional medical plan. What about our Southland benefits?
On Southland, you can enroll anytime during the year. The effective date is the first day of the next month. But when you elect Southland, you are enrolled for a minimum of 12 months, and then you can cancel the next open enrollment if there's no qualifying event. On family coverage, you can add dependents the first day of the next month, or if you acquire a new dependent, it can be the date of the qualifying event if we're notified within the 60 days.
Okay, what about canceling coverage?
Canceling Southland, you can do it during open enrollment as long as the 12 months has been met for the subscriber and also the dependents.
How many of you guys cover retirees? Okay, more than I thought, but these are so important. We wanted to re-emphasize them, and they look very confusing, but they're really not. They're mainly just a couple of scenarios, and if you'll walk us through those scenarios.
The first scenario would be service retirement. It's 25 years of service, and the key word there is years of service, 10 years and age 60. But the main requirement is to be on the local government plan for 10 years, or if your unit's been enrolled less than 10 years, to be enrolled from the time the unit joined until retirement.
And what about the disability retirement?
On disability retirement, you need to apply for Social Security, not retirement systems. It can be also retirement disability, but you need to apply through Social Security for a disability, and we need proof that you applied for the disability. And then after that, we're going to cancel the contract, offer 18 months of COBRA, and while the 18 months of COBRA, we're pending the Social Security determination, whether it's been approved or denied.
Let me jump in. Does that application to Social Security, does it need to take place prior to retirement?
Prior to retirement, and we need to be notified 30 days before the retirement, but the disability needs to be applied before the actual retirement date.
Okay, what happens if the Social Security application is approved?
If it is approved, then you'll be converted from COBRA to a not Medicare retiree.
And how long does that coverage last?
24 months, or until you get Medicare.
Okay, so if the person gets Medicare during those 24 months, they'll automatically be converted to Medicare coverage or Medicare Advantage.
Coverage.
And if they do not, the coverage would end after the 24 months. What about if the disability application is not approved?
If it's not approved, then you would be offered the 18 months of COBRA, and the COBRA would end unless it's a qualifying event for 29 months.
All right, what about those units that offer Medicare coverage? What do they need to know?
If they offer retirees Medicare coverage, they need A and B. Of course, notify us within 30 days of retirement, and then they'll automatically be enrolled in United Healthcare, the Medicare Advantage plan.
And why is that 30 days so important?
The 30 days is important because according to Medicare, we have to give a 21-day opt-out notice to notify them they're being enrolled in case they want to cancel it.
And so guys, again, can't stress that enough. It's very important that we get that 30 days notice prior to retirement going on Medicare.
On the disability retirement.
Her question is, when you do disability retirement, when does the 18 months start? And it would start at retirement.
So the 18 months is to allow the opportunity for that Social Security application to be acted on. All right, so the next question is, which of the following is not an eligible retiree? We've got A, Dustin is 50 years old with 15 years of coverage and 26 years of service with his employer. B, David is 59 years old and determined to be disabled by RSA. He has 17 years of coverage in service with his employer. C, Rob is 62 years old with 12 years of coverage in service with his employer. Or D, Jason is 55 years old with 25 years of coverage in service with his employer. Your nose, right here? That is correct.
Correct.
B, David is not eligible because he was determined to be disabled by RSA and not Social Security. Okay, here is a chart that I think is very important. If you want to take a picture of it, take a picture of it. But it is a chart that boils down all of our forms. And we're going to walk through these forms and why they're important. So let's start with the beginning on the enrollment and declination form.
On the enrollment form, it's used to enroll an employee in the local government plan for the Blue Cross, Optum. We've got a new form we'll discuss in a few minutes when we get further in the forms.
That's right. We heard you, and we have separated the Southland form back out. And so Southland is no longer... Look, I'll take the blame for that. I was trying to consolidate it and make it simpler, but I realize now in hindsight that was a mistake. So, all right, what about our status change form?
We'll back up on the enrollment form. For new employees, it needs to be done immediately on elected officials within 30 days of assuming office. On the status change form, you would change an employee's name, date of birth, correction, email address, and that needs to be done as soon as possible so we can get their mail to them. And also, especially on the retirement, we need those as soon as possible.
And the new dependent form?
On the new dependent, within 60 days of a qualifying event, which would be whether they're going from single to family or if they're adding a dependent to family coverage.
All right, and then the dependent cancellation form.
Dependent cancellation is from family to single or canceling a dependent. And again, that needs to be within 60 days of the qualifying event.
Okay, and finally, the cancellation form.
Cancellation form is going to be used for termination of employment, if someone is retiring and not keeping the insurance, military leave, leave without pay, and we need to be notified immediately.
Okay, so here's our list of Southland forms that we've broken out again, and these basically go back to what we had 2 years ago, I believe. So talk about these forms.
The Southland is going to be Form LG07. If you want to enroll in Southland, you can do it anytime during the year or open enrollment. And then on the Southland voluntary change, you can add or drop dependents. The open enrollment is the deadline unless there's a qualifying event. And also on the Southland cancellation, as long as they've met the minimum 12 months during open enrollment, November 30th deadline.
All right, so how do they submit this documentation to us?
You can submit it through email. We heard your request, so send it to enrollments@lghip.org. We would prefer if you would send it secure. You can email enrollments and ask for a secure email, and we'd be glad to send it to you that way. And then also you can mail it, the traditional mail. It takes a little bit longer to get there. Or on enrollments, you can process them through the online enrollment system.
And so, as the privacy officer, I can't emphasize enough how important it is to send that securely if you can. Because we're talking about information that has Social Security numbers on it, and it's going across public networks when you're sending it through email. It's very important that it's sent securely. So please contact us if you don't have a secure, if you have your own secure email service, that's great too. But if you don't, contact us and we will send you a secure email so that you can reply to that.
It's easier if you get a link from our office because on some of them we can log in and open it, some of them we cannot. I know there's several out there we've had problems of trying to log in to retrieve the information.
But if you want to send us a test, we'll be glad to test it out and see if that is one that we could work with. All right, that is our presentation. Any questions? I'm sure there are.
On the change for the eligible dependent, with the under age 19 for whom you have, the person has legal granted custody or physical custody, this would be the first open enrollment that those individuals could be added. And are you looking for the court document to be attached? And so that we would probably get a Social Security card and that document, but what would we send to you to get that defendant added?
It would be the court papers where the judge has signed it.
So we don't need birth certificate because
We're not looking at the relationship. Before, when it was grandchild, niece, or nephew, we were trying to prove that relationship, and now you don't have to prove it.
Okay, so if we've got an employee that's going out on medical disability, we don't have the Social Security stuff yet. So if he elects the COBRA and then the Social Security is approved, will he then roll back onto our bill and then, because we don't pay any of the retiree coverage. So then he would be responsible for what, remitting it to the county and then we pay it with the bill?
Correct.
He'll come off of the bill while he's on COBRA and then go back on it. Will we be notified that he's going back on it, or will it just show up? Because we'll have to collect that money from him.
Her question is, when you have a disability, when they go on COBRA, when they come back to the unit, you're going to probably notify us that they have been awarded disability. We're going to, first off, when you cancel them, we're going to need the cancellation form, and then we're going to need proof that they applied for disability, and then something from your unit saying they meet all the requirements. And then they'll go on COBRA, and during that 18-month time frame when they get awarded disability, then they're probably going to contact you or our office. We're going to ask for a cancellation for COBRA to cancel it if it's not the end of the 18 months, and then an enrollment form from you letting you know, then they'll show up on your bill.
So basically we have to re-enroll them?
Right, because they're coming from COBRA back as a retiree. And we'll need to know Medicare, not Medicare, also on their dependents, if their dependents are Medicare or not Medicare. And then you'll know they'll be on your bill and to collect from that retiree.
Coming in hot. When a dependent reaches the age 26, we all automatically remove them, or do we need to send a form?
Her question is, when a dependent reaches age 26, it also applies for custody at 19. They are automatically removed with our system, and then we will send them a COBRA notice, and then you should get an email saying that dependent has been canceled.
We just had that happen, and y'all also automatically changed that member from family to single because he no longer needed family coverage because his daughter aged out. And y'all changed, the next bill I got, he had been changed from family to single, like it should be.
Correct. You should get an email from us saying that they've been changed family to single in case you need to change the payroll deduction.
All right.
One question, for the medical support order, I recently had a child custody court paperwork that came through to us, and in it said, as of this date, the employee needs to provide medical coverage for the child that custody was being assigned to him for. And when I sent the paperwork through the enrollment department, they said that doesn't count as a qualifying event, that they had to have lost coverage somewhere in order to start covering them. Is that right?
Because it was not a national medical support notice.
Okay, so that's different than
Yes.
just in a legal, okay.
Right. Yeah, so a national medical support notice, it's not a court order. It's going to come from typically DHR, but it's a child support agency, and it's on there are special forms that they come on because there's one, it's just like a child support order, right? It's going to have an employer response where you guys have to fill it out, but then there's also a plan administrator response page that we have to fill out and sign back. That's another important point. From time to time we get those, and you guys or units have already filled out the plan administrator portion, please don't do that. Please just fill out, because then we have to send it back to you and ask you to white it out. And it's just much easier if you just sign your portion of it and then send us the plan administrator response, because I complete those and then send them back to you guys. Thank you guys. If you have any questions and you want to talk to us, we'll be over here.